If you have a restraining order court hearing coming up and you are planning to represent yourself, or even if you have an attorney, I'm going to be giving you a piece of information in this video that could make the difference between winning and losing your hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to have your best chance at representing yourself and winning your restraining order hearing. Okay, so let's jump right in. The piece of information that may make the difference in winning or losing your restraining order hearing, and it is very, very easy to implement. If you show up for court, and generally how it works is that a deputy, a bailiff, will come out of the courtroom. Sometimes it's a clerk, but usually it's a bailiff, and make an announcement saying there's a temporary judge today, maybe even talking that person up a little bit about how this is the same as a real judge, and asking everybody to sign a piece of paper stipulating or agreeing to the judge pro tem. Say no. Do not stipulate to the judge pro tem. Okay, so let me explain what's actually going on in this situation, why I'm telling you to say no to that, and the potential consequence. In most courthouses in California, especially in very busy counties, the lowest level of the totem pole in terms of how important the court feels cases are, the very lowest level, or at least one of them, maybe even lower than small claims, are restraining orders. It's a lot of people representing themselves like in small claims court. Nobody gets ordered to pay any court fees like you do in criminal court. There are no filing fees like there are in civil court, including even small claims. And so these are really just the bottom of the totem pole in terms of what the court cares about. Actually, I was recently doing a strategy session for somebody where I was giving him advice on what to do for his restraining order hearing, kind of listening to the whole situation. And he said something really funny that was also really insightful. He called restraining orders the lost leaders of the court system, right? It's free to get in. The court is taking a loss on them. But after your restraining order hearing, maybe now you have to go to family court where there are filing fees to pay because you have to deal with child custody or divorce, or you have to go to unlawful detainer or eviction court, or you have to go to civil court maybe because you can't afford to pay your credit card bills because you put your Airbnb on them when you were kicked out of your house because of your restraining order. So, it's true. When he called them the lost leader, I was like, absolutely, that is kind of how the court deals with them. The court only has so many judges to go around. They only have so much budget. I'm sure nothing's getting wasted there, right? But they only have so many resources. And so they have to cut corners. And for these restraining orders, it is a drain on the court because there are so many of them and because they have to be heard in a very short period of time. The first hearing is set about 21 days from the time that the initial temporary order is issued. So what they do is they have these volunteer judges. So this is what a judge pro tem is. It is an attorney who volunteers for the court to work in an area of law that they don't need to have any experience with. In fact, the court prefers to assign attorneys to cases outside of their area of law, because it minimizes the possibility of there being a conflict of interest. For example, if you were a family law attorney and now your former client shows up in restraining order court, well, now you have a conflict of interest and you can't hear that case. And so the court didn't really solve their problem of having a free judge, a volunteer judge, sit there and review these cases. So the court tries to avoid that. And the result is that you have attorneys who don't know anything about the area of law that they have been assigned to. Maybe they did some online training for a few hours, but that's it. They've never practiced in it. They don't know anything about it. And yes, you do learn about a variety of areas of law in law school, but you don't necessarily learn about all of them. And you have to have been an attorney for at least 10 years. That is one qualification, at least in Los Angeles, to be a temporary judge. So that means that maybe the last time you heard about anything involving the area of law that you have been assigned for the day was more than 10 years ago when you were back in law school. And for restraining orders, the law is important. What counts as abuse and what doesn't? Now, I typically represent respondents and give advice to respondents. There are a lot of free resources for petitioners out there. But as an example, what if you are a petitioner and the basis for your restraining order is threats, harassment, maybe texting you from all different phone numbers? You block one and there's another one that pops up, maybe standing outside your house, You look out and the other person, there they are. But the attorney who is assigned there as a judge pro tem thinks, well, this is a domestic violence restraining order. I'm not hearing any violence here. And so they deny your request for a restraining order. Now, absolutely, if someone is stalking you and harassing you and disturbing your peace, that can be a basis for a domestic violence restraining order in the state of California. Or maybe they get confused as to what the legal standard is. Maybe they think that you as the respondent have a duty to present evidence, which is not true. The petitioner is the one who has the duty and the burden of proof. Maybe they get the different types of restraining orders because they do have different standards and different types of evidence that can be allowed in. Like for civil harassment, you can use hearsay. You cannot for domestic violence restraining orders. Maybe they get that confused. And it can really screw you over. And good luck, especially if you don't have an attorney and you are representing yourself, correcting the judge on the law. Even as an attorney, when I do that, I have to be careful in the way that I say it because the judges have so much discretion in these restraining order hearings. So you have to be careful that you don't insult the judge. And before you correct the judge, you better be really freaking sure that you are correct, right? Well, you can represent yourself in a restraining order hearing and potentially win. When you are in that courtroom, I mean, it's not your world, and you have an attorney up there who may or may not be nice, may not have great temperament. Attorneys are not known for having great temperament, right? It may be very, very difficult for you to attempt to bring that up and to say, hearsay is not allowed in a domestic violence restraining order hearing, Your Honor. This isn't civil harassment, because they may actually put all the restraining orders together in one courtroom, especially if they are that busy, and then the judge has to keep all this straight. And not every lawyer got straight A's. We all had to pass the bar. How many times did it take the judge pro tem to pass the bar? Maybe more than one. I'm not trying to insult anyone here, but I would not ever let this person decide my fate if I had a restraining order in front of them. Frankly, I wouldn't even let them decide my fate in traffic court. What if I'm eligible for driving school instead of points on my license, but the judge doesn't know that? I'm just not going to take the chance. And that is something that really isn't that important compared to restraining orders because the outcome can be very, very serious. Now, what happens if you or your attorney tell the deputy that you don't want to stipulate to the judge pro tem? Well, there are a few things that can happen. First of all, is anyone going to be mad at you? I doubt it. Usually this happens before the judge is even on the bench. Sometimes the deputy or the courtroom personnel can seem a little bit frustrated. Who cares? Just be polite. You don't have to go along with the judge pro tem. You may see everybody else is going along with the judge pro tem. That's because you know something that they don't, right? They're just thinking, I don't even know what that means. That's in Latin. You're saying it's a judge, the deputy's trying to encourage me to do this, everybody else is doing it, and so they, like sheep, go ahead and go with the judge pro tem. But what will happen is that you will either get another court date to come back, or you will be transferred to another courtroom. Now, getting transferred to another courtroom, that really just depends on the availability of other courtrooms. And that other courtroom may also not be able to hear your case that day, and so you may end up getting another date to come back. Now, another date to come back means that there's a continuance. It means that your hearing will not be on the day that it was set for. This can be a big problem. I know for respondents, petitioner probably doesn't really care, but for respondents, if you were kicked out of your house, you can't see your kids, for example, maybe you can't see your pets, it can be a really big deal to think, I'm extending this temporary restraining order. However, if you go forward with the hearing and you lose, then all those ways that you were suffering are only going to be extended. And it can be very difficult to appeal these decisions. So while there may be some exceptions to this, generally the least risky thing to do would be to not go forward with the judge pro tem, even if it means that there is going to be a continuance. How long of a continuance? Typically it's going to be at least 3 weeks because the restraining order hearings get set for about 3 weeks out. Now, if you have an attorney and they want to go forward with the judge pro tem, you have a right to ask them why. A lot of attorneys will just go along with the judge pro tem. Why? The same reason that the people who are not attorneys are going along with it. Maybe if they're a new attorney, they don't really understand what that means. Maybe they don't understand the process. Maybe the other people are going along with it. Maybe they just want to get out of there and they want to finish up the case, win or lose, and so they don't want to continue it. I'm sorry to say, but that could be the case. And I mean, one reason why I might be tempted to go with the judge pro tem would be if the other side doesn't have an attorney, my client thinks that the other side might get an attorney, and they don't have one that day. However, even in that case, I still don't think it is worth the risk. I've known people who serve as judge pro temps, and at least one of them, if I were a man, I would never want hearing my case because I think you would have an uphill battle. I typically represent men at these hearings. I would never let my case be tried in front of that particular person. But that's just one person who I know about, who I got to know. This isn't a friend, by the way. What about all the other attorneys out there who are not elected by anyone, were not appointed by anyone, didn't go through that vetting process? Instead, they just decided, you know what? I'm not all that busy, and I think it would be fun to play judge for the day, so I'm going to volunteer as a judge pro tem. Whatever issues that person has going on in their mind, I have no idea about, right? I don't know. There's no vetting for these judge pro tems. So you are taking such a big risk going forward with them that it is not worth it. I hope you found this video helpful. If you do have a restraining order hearing coming up, look, you can keep scrolling through YouTube, hoping to find the answers. And there are a lot out there. I make videos on restraining orders all the time. But the thing with learning something new is you don't know what you don't know. And so it's generally easier to have a guide that teaches you, hey, here's what you need to know. And then let's go through it and I'll teach you each thing. And that's exactly what I do in my course, Defeat the DVRO. So if that is something that you are interested in, you have nothing to lose. You can get a free first class via the link down below. And if you did find the video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.